Good afternoon, everyone. Welcome to the Faculty of Law, Chulalongkorn University. A warm welcome, and today we are hosting a 𝗪𝗲𝗯 seminar series on celebrating the 75 years of the Universal Declaration of Human Rights, assessing the four freedoms. We are doing this in cooperation with the Institute of Human Rights and Peace Studies, Mahidol University, and the University of Swansea. For information, the simultaneous translation is available. We'll be doing the seminar in English, but if you want to prefer to listen to the seminar in Thai, the simultaneous translation is available, and you can pick up the device at the entrance of the door. And of course, some of the speakers will be joining from overseas via the Zoom. Without further ado, may I now first invite Dean 𝗪𝗲 𝗪𝗏, Dean of the Faculty of Law, Chulalongkorn University, to give a welcoming remark. Thank you.
Swadika and good afternoon. Dr. Seri Nontasu, the keynote speaker, Mr. Edmund Bon Tayusun, Professor 𝗪𝗲𝗪𝗀𝗀𝗀𝗀𝗀, Professor Mark Kapaldi, Dr. 𝗪𝗲𝗪𝗀𝗀𝗀𝗀𝗀, ladies and gentlemen. And Professor Dr. Amara. On behalf of the Faculty of Law, Chulalongkorn University, I am delighted to welcome all of you to our 𝗪𝗲𝗯 seminar series on human rights. 𝗪𝗲𝗯, or the Faculty of Law at Chulalongkorn University, has been at the forefront of human rights education in Thailand, thanks to the legacy of our very own world-class Professor 𝗪𝗲𝗪𝗀𝗀𝗀𝗀𝗀, who has been appointed as a special rapporteur to various UN mandates, and who is still currently working full-time with us at Chulalongkorn University. And our human rights team is strengthened further by Dr. 𝗪𝗲𝗪𝗀𝗀𝗀𝗀𝗀𝗀, the first Thai representative to the ASEAN International Governmental Commission on Human Rights, or IAICHR, who has much experience in human rights education, international publications, and human rights advocacy. Thanks to her initiation, we are organizing a series of human rights academic seminars to celebrate the 75th anniversary of the UDHR. The focus of today's seminar is on the right to life. Even though this is probably the most famous, most cited human rights, the implementation still needs further investigation. For example, the death penalty is still carried out in many countries, including Thailand, sparking debates and proposals on whether this sentence needs to be abolished. As Dean, I am very happy and honored once again to see that our faculty continue to live up to our purpose and commitment, which is to become a more global research university that teaches. It is so refreshing to see that our faculty members, Dr. 𝗪𝗲𝗪𝗀𝗀𝗀𝗀, Dr. Parvat, the Vice Dean, who also moderating the panel discussion today, participate in this global dialogue. I would like to thank our co-organizer, the Institute of Human Rights and Peace Studies, Mahidol University, the University of Swansea, for your support. I am certain that this marks as the start of our closer collaboration between our institutions. I would also like to thank my team, the 𝗪𝗲𝗯 Research and Academic Resources team under the direction of Vice Dean Parvat, for making today's seminar possible. I wish this seminar a great success, and so I declare that the seminar to celebrate the 75th year of the UDHR assessing the four freedoms right to life open. Thank you.
Thank you very much, Dean 𝗪𝗲𝗪𝗀𝗀𝗀𝗀, for your welcoming remark. Next, I would like to invite Dr. 𝗪𝗲𝗪𝗀𝗀𝗀𝗀𝗀𝗀𝗀, also the Director of the Institute of Human Rights and Peace Study, Mahidol University, to give a welcoming remark, and she's joining us live from Zoom.
Thank you very much. Can you hear me? Okay.
Yes, very clearly.
Great, thank you. Professor 𝗪𝗲𝗶𝗀𝗃𝗪, Dr. �ร Assistant Professor Dr. 𝗪𝗲𝗃𝗪, distinguished speakers, ladies and gentlemen, a very good afternoon from Salaya. I'm very honored to be delivering these opening remarks and to welcome you to this seminar on the right to life. And my apologies for not being able to join you in person. In a world filled with diverse perspectives, beliefs, and ideologies, there is one principle that unites us all, and that is the right to life. The right to life is also recognized as a fundamental right that underpins all human rights. In the 21st century, the right to life faces complex and multifaceted challenges, including threats to human life from violence, discrimination, environmental crisis, and disparities in healthcare. At the same time, death penalty, the topic of our discussion today, constitutes a more explicit and direct violation of the right to life. Southeast Asia, and in particular ASEAN, has been a region of particular concern when it comes to the application of death penalty. 8 out of 10 ASEAN countries still have laws that allow capital punishment for various crimes. Studies have shown, as you will be hearing more from the speakers today, that there are a number of factors that contribute to the retention of death penalty by ASEAN governments. Cultural and societal beliefs can play a significant role in shaping a country's stance on the death penalty. In many ASEAN countries, there seems to be strong public support for capital punishment as a means of addressing serious and not so serious crimes. Political leaders may be hesitant to abolish it if they believe it aligns with popular sentiment. Likewise, political leaders may use the death penalty as a tool to appear tough on crime and maintain law and order. This can be a political strategy to gain support or maintain control. Another argument that we often hear about is that the death penalty serves as a deterrent against crime, although this is debatable. Many studies have failed to establish a conclusive link between the death penalty and a reduction in serious crimes. On the other side, those of us who are against capital punishment are aware of why such an act constitutes a violation of the right to life. One of the most compelling arguments against the death penalty is the potential of irreversible errors. There have been numerous cases where individuals are wrongfully convicted and sentenced to death, only to be later exonerated due to new evidence. The execution of an innocent person is a tragic and irreversible violation of the right to life. The methods of execution used in some countries can be cruel and inhumane, potentially causing severe physical and psychological suffering. This can include methods such as hanging, firing squad, electrocution, or lethal injection, which may not always result in a quick and painless death. There is also evidence to suggest that the death penalty is often applied disproportionately to marginalized and vulnerable populations, including racial and ethnic minorities, and individuals without access to adequate legal representation. This raises concerns about systemic bias and discrimination in the criminal justice system. The act of taking a person's life as a form of punishment can be seen as a violation of their inherent human dignity. It sends a message that society sanctions the killing of individuals even in retribution for heinous crimes. There's a growing global consensus against the use of the death penalty. The majority of countries have either abolished it or instituted a de facto moratorium on execution. Capital is increasingly seen as archaic and out of sync with evolving human rights norms. The Institute of Human Rights and Peace Studies, Mahidol University, has this privilege of co-hosting this seminar with an impressive array of experts, scholars, and advocates who will share their knowledge, insights, and experiences. Through their contributions, we hope to gain a deeper understanding of the complexities surrounding the death penalty in ASEAN, and ultimately to engage in a meaningful exploration of potential reforms and alternatives. I would like to express my gratitude to Faculty of Law, Chulalongkorn University, the University of Swansea, our distinguished speakers, and all of you who are present today on site and also online. I know that a number of students from Mahidol universities are participating online as well. Your participation signifies your commitment to engaging with one of the most pressing human rights challenges of our time. And together, we can contribute to a world where justice is served, human rights are respected, and the dignity of every individual is upheld. So with that, I would like to officially open this seminar on the right to life. Thank you very much.
Thank you very much, Dr. Chula, for your welcoming remarks. Next, we will have the keynote speech from our former Thai representative to the Asia and the current UN Committee on ICSCR. By the way, need I mention that we are now having 3 Asia commissioners all in one room, Professor 𝗪𝗲𝗹𝗰cie, Professor 𝗪𝗲𝗪𝗏, and Dr. Serin Nonthasoot. So a very rare occasion. But anyway, right now, let's move on to the keynote speech. Today we are honored to have with us Dr. Serin Nonthasoot, who will be giving a keynote speech on the protection of the right to life. Please.
Good afternoon. Indeed, it's a delight and honor to be here. I just observe as well that there are 3 current and former AICHA representatives of Thailand in this room. So such a delight to be in the presence of my colleagues. And greetings to those who are online as well. It's unfortunate that we don't get to meet them in person. I look forward to meeting all of you in the future. Now, the topic of my discussion today is protection of life. Of course, I like to start by examining the current jurisprudence at the UN level. Can we pull up the presentation? Those who are online, I'm sure you will be able to see more clearly than those in the room. I just observed that the screens are a little bit too small. If we can move to the second page, please. When we talk about right to life, article that is applicable is Article 6 under the International Covenant on Civil and Political Rights. There has been a general comment before, and in 2019, the Human Rights Committee, the treaty body that monitors implementation of the ICCPR, decided to renew and reissue the general comment on right to life. So this is the current jurisprudence of the right to life. And I just want to highlight some salient points that will be expanded later. I just want to highlight the fact that in Article 6, the Human Rights Committee clearly announced that right to life itself pertains to and relates to other human rights. It doesn't stand alone, and this is a very crucial fact to always consider. And the second point is Article 6 and right to life in particular should not be narrowly interpreted. Still maintain on the first page, please. I'll let you know when we move. Can we go back to, yes, please, thank you. I'd like to highlight one paragraph from the general comment 36 as it stands now. There are 37 of them for the Human Rights Committee. The right to life requires, when we talk about protection of life, right to life requires state parties to take special measures of protection towards persons in vulnerable situations whose lives have been placed at particular risk because of specific threats or pre-existing patterns of violence. And they go on to talk about different groups of people, including refugees, asylum seekers, children in street situations, unaccompanied migrant children, and children in situations of armed conflict, members of ethnic and religious minorities, indigenous peoples, lesbian, gay, bisexual, transgender, and intersex persons, persons with albinism, alleged witches, displaced persons, asylum seekers, and stateless persons. So I appreciate the breadth of reference to specific groups under this particular paragraph, but it shows us that right to life operates and protects these specific groups. We can then move to the next page, please. In the next page, when you read Article 6, what tends to happen is that because of the proximity and the clustering of these provisions, when we talk about right to life, we generally associate right to life with justice system. I want to decouple that understanding to say that right to life must be understood much, much more broadly. And that has been reiterated by the Human Rights Committee under the General Comment number 36. So we need to put a broader lens apart from the criminal justice area that we normally associate with right to life. Second point is when we talk about limitation, of course, right to life can be limited, especially through the terms arbitrarily deprivation. So if it's not arbitrary, right to life can be limited or even terminated, but under the lens of arbitrariness that is expanded already in General Comment 36. I want to highlight Article 4 also, that derogation or limitation can be done through situation of public emergency, but the stress or the emphasis is on discrimination. You can't discriminate even in the situation of public emergency, and no derogation from Article 6 may be made under this provision. We can go on, please. When I say that we need to decouple and put a more broader sense of scrutiny when we talk about right to life, it operates in every situation of life. I want to highlight two situations. The first one is life in armed conflicts, which are ongoing in the world. We talk about Syria, Yemen, Ukraine. We have in the Committee of Economic, Social, and Cultural Rights, you understand that we have two covenants, the twin covenants. One, the ICCPR, the other, the ICESCR. And these two covenants stem directly from the UDHR in 1966. Of course, we operate interdependently and interrelatedly, meaning when we examine the situation, we always look at the ecosystem that promotes protection of life. When we talk about armed conflict, my question is, what do we do in the situation of failed states? And we have had the occasion or the opportunity to examine that particular situation in the context of Yemen. Yemen is, when we can call it a failed state at the moment. It's in the crisis, it's in war, it's in armed conflict. So we ask first, how can you live in that situation? And what about right to life, the most basic of rights? The Committee on Economic, Social, and Cultural Rights stressed two facts. Number one, we look at the fact that humanitarian law operates in conjunction with human rights law. So even the situation of armed conflict, human rights laws operates. And this is just a reiteration of the pronouncement made by the ICJ in the case concerning Palestine, the Palestinian territory, which states that protection offered by human rights conventions does not cease in case of armed conflict. So even in armed conflict, all human rights standards apply. So Yemen has been asked to be accountable for the ecosystem in which human rights must be protected. And we say to them that applicability of international humanitarian law does not preclude the application of international human rights law, particularly the two covenants, namely right to life and economic, social, and cultural rights as well. So the same standard can be used in situation of Syria, in situation in armed conflict anywhere in the world, particularly now in Ukraine and Russia. My second scenario when we talk about right to life, can we turn to the next page, please, is a very recent example of COVID-19. We understand that when vaccines became available in 2020 or early 2021, the problem was who got the vaccines. And vaccines were necessary to sustain life and other human rights. So the Committee on Economic, Social and Cultural Rights made a pronouncement, and this should, and I stress, should become an international standard in that particular situation. So we acknowledge the fact that prioritization must be made in the distribution of vaccines. They're not available for everyone. They are available to someone, some groups. Which groups got the vaccines means that they are more likely to survive. So the committee made the decision to make this pronouncement to say that the prioritization of vaccine distribution must be based on medical needs and public health grounds. More importantly, we say that through a process of adequate public consultation, it must be transparent and subject to public scrutiny, and in the case of disputes arising, to judicial review to avoid discrimination. This is a standard that we are holding governments accountable to see if they distributed vaccine in an equitable manner. Of course, in the same statement, we examine the behavior of private companies that use IPR to withhold or to selectively distribute vaccines to certain countries and certain groups before other countries and other groups. If you turn to the next page, please. Now, when I say that a broader lens must be associated with the right to life because it applies to every situation, I want to say that we have SDG 16. Within SDG 16, a global goal that doesn't depend on any membership of a human rights treaty because it applies to every country, and every country has made a pledge to undertake and implement the global goals on sustainable development. Not many people realize that under SDG 16, the first target is to reduce violence everywhere, and this includes right to life, the protection of right to life. If you turn to the next page, you can see more clearly what this means. I show you the data from Thailand. Next page, please. Thailand in 2011 made this data available that when the UN say SDG 16, goal 1, target 1, they talk about homicides. And they look at the number of homicides per 100,000 population. Can you imagine that in 2011, there were 4.8 people who died from homicides in every 100,000 people? How can a society be sustainable if human lives can be put at risk anytime? And also, we have a situation of unsentenced detainees that should be mentioned. I'll come back to this one later on. If we go on to the next page, please. The Human Rights Committee in 2017 asked Thailand to consider abolishing the death penalty and accede to the second optional protocol to the covenant, the one that proclaims abolition of death penalty, aiming at the abolition of death penalty. If the death penalty is maintained, the state should take all measures necessary, including legislative action, to ensure that it is limited to the most serious crimes, such as acts carried out with intention of killing. Can we go to the next page, please? If you can scroll down. I made this quick translation that 700 years from the day when King 𝗪𝗏𝗏 of Lana, King 𝗪𝗏𝗏, before Thailand is the land it is today, we have another territory in another kingdom actually in the north. And King 𝗪𝗏𝗏 is known for his code of law. We call it Code of 𝗪𝗏𝗏. It dates to more than 700 years ago. Back then, 700 years ago, death penalty is pronounced on on a menu of offenses. And these offenses include murder, stealth, plunder, murder as a means for stealth, destruction of monasteries and assembly halls, accommodating the subject of a nobleman in one's dwelling, burglary of monks, children committing parenticide, killing your parents, fratricide, killing your brother, or sororicide, killing your sister, and dominicide, killing your master. What happens now if we juxtapose 700 years ago to current situation? I made a quick search last night, and I thank the correctional department that makes available this data. Next page, please. On this page, I doubt if you can see it clearly. Let me tell you the salient facts. At the moment, we have 267 people on or with the death sentence through the appellate court and through the Supreme Court. There are 36 with the death penalty as a final verdict. Among these, we had 16 drug offenses and 20 general offenses. If you recall, during the reign of King 𝗪𝗲, drug offenses were not subject to death penalty. They are now. So it's worth examining what kind of seriousness or the most serious crimes when you put to scrutiny, what type of offenses we hold accountable to the death penalty. And of course, among the 267 subject to death penalty, a few are women, majority are men. So we progress as a country. What about in terms of fairness, in terms of the Article 6, protection of life? How much better do we fare from the time of King 𝗪𝗲, 700 years ago? That is a question. Next page, please. Now, the most current status of the death penalty when it comes to drug offenses. This is the most current report issued by the Office of the High Commissioner on Human Rights. And I'm associated myself with this report because I'm undertaking the development of a general comment for the Committee on Economic, Social and Cultural Rights on drug policies and the impact on economic, social and cultural rights. The Office of High Commissioner on Human Rights state clearly that experts recall that crimes not resulting directly and intentionally in death, such as drug-related offenses, should never be sanctioned by the death penalty. It seems to be a strong statement, and I like to associate myself with that one also. And at the moment, 35 countries retain the death penalty for drug offenses. Reportedly, executions for drug offenses account for 1 in 3 of our executions carried out globally. So we need to recognize the seriousness of the issue of drug offenses too, and how do we can make a reform on that. Next page, please. If you look at the Constitution of Thailand, which dates to 2017, you will recall that in 2017, Thailand submitted and got the concluding observations from the Human Rights Committee, which asked us to abolish the death penalty. What do? We've had this, I call it a hope. In our section, in our Article 7 of the Constitution says that Thailand should introduce laws only to the extent of necessity and repeal or revise laws that are no longer necessary or unsuitable to the circumstances or are obstacles to livelihoods or engagement in occupation without delay. Secondly, we should only prescribe criminal penalties only for serious offenses. I think we can use the Constitution to say that from now on, this lens of more serious crimes are in sync with what we've had in Article 6 of the ICCPR. So we need to make a reform of any law that carried out criminal offense and penalty, especially death penalty too. Perhaps my last page, next one please. And it's this book, the special occasion to launch this book. I have a lot of things to say about this book, but just within this time limit, let me just say this. This is the first time that there is a book that put a regional lens on the death penalty. So among the 10 countries of ASEAN, and by the way, in 2015, we say to the world that we are a community of 10 countries, and we are here to prosper collectively. So it put into question, what kind of community is it that still allows certain countries to put human lives at risk of the death penalty? So the agency and regional approach of ASEAN is called for. And I'm very glad that this book is published in a timely manner. I had the pleasure of writing the preface of this book. You can read it in detail. But unfortunately, my preface was written at the time when Myanmar threatened to use the death penalty. It actually used the death penalty at the end. So right now, certain corners of ASEAN regressed to use the death penalty. We have to pin our hope with countries that already abolished the death penalty and not to revert to use it any longer. I just want to end my intervention or presentation by saying that apart from looking at the right to life in a much broader context, we need to be aware of the current situations and opportunities that are available. For example, through the Thai constitution, through law reform in many countries. I know that Malaysia is trying to abolish the mandatory death sentence and kudos to Malaysia. I look forward to seeing progress on that. And Laos will be chairing ASEAN next year. I hope that we can make progress under Laotian chairmanship of ASEAN as well. So I end with hope that progress can be made on the right to life. Thank you very much.
Thank you very much, Dr. Seri Nontasood. At this time, shall we take a group photo on the stage? May we invite all the speakers, Ajahn Amara, Ajahn 𝗪𝗲𝗯, Ajahn Mark, and Ajahn 𝗪𝗲𝗀𝗰𝗍𝗋, please. In the next part of our seminar, we'll have a panel discussion. So without further ado, may I invite all the panelists, Dr. 𝗪𝗲𝗪𝗪𝗀𝗪𝗔, Dr. 𝗪𝗲𝗪𝗀𝗪𝗀𝗪𝗃𝗀𝗪, on the stage, and as well as other panelists joining us from overseas, Professor Mahidol and Mr. Edmund Bunthaisorn. Please. Good afternoon once again, and welcome to the panel discussion on assessing the freedom from fear after 75 years of the UDHR. In fact, what Dr. 𝗪𝗲 𝗏𝗀 just mentioned just now, I think he summed up everything about the right to life, and actually he just launched a book on the unpacking the death penalty in ASEAN. But today, in this panel discussion, we are honored to have some of the contributors who contributed to some chapters of the book to talk about the death penalty in ASEAN in the umbrella or the realm of the right to life. And I have to mention that because of the initiation by Dr. 𝗪𝗲𝗹𝗲𝗀𝗀𝗀𝗀𝗀, a very energetic individual, this panel discussion has come into fruition. We label this as assessing the four freedoms as part of the UDHR because we like to play with the theme on the four freedoms that was famously pinned by the former US President Franklin Delano Roosevelt because he famously addressed the four freedom speech in 1941 at the State of the Union address. Just for reference, the four fundamental freedoms he mentioned were the freedom of speech, of worship, from want, and from fear. But also, although the basis or reference to the four freedoms in his speech, it was on the First Amendment of the U.S. Constitution and on the U.S. Bill of Rights, we must acknowledge that these principles are now embedded in various international human rights instruments, including the UDHR. For the freedom of speech, the first one that we did with the series, we did a seminar on the strategic litigation against public participation back in July, and that was the freedom of speech. And we did the SLAP seminar to assess the situations in Thailand where business enterprises were using SLAP against human rights defender. Today is the second of our series. We'll discuss about the freedom from fear, and we'll look at probably the most known human rights, the right to life, and with collaboration with the contributors of the book. We will discuss on the death penalty, whether or not it should be abolished, how, and the way forward. Very briefly, because I will introduce them again before the speech, but very briefly, we have four contributors today with us on this panel discussion. The first is Dr. 𝗪𝗲𝗹𝗪𝗀𝗀𝗀𝗀 from Faculty of Law,ฬាលង្ករ University. Second, Professor Mark Peter Capaldi from the Institute of Human Rights and Peace Studies, Mahidol University. Next, we have the Professor Maita Teresa CHAN-GONZAGA from Ateneo Law School, the Philippines. And the last, we have Professor 𝗪𝗲𝗪𝗀𝗀𝗀𝗀𝗀, former Malaysian representative to the 𝐂𝐡𝐻R. So very happy to have all of you with us here on the premise and also online from your own country. So let's first go to the speaker. So the order of the speaker will be the first Dr. 𝗪𝗲𝗹𝗪𝗀𝗀, then followed by Professor Mark Capaldi, then third Professor Maita, and then lastly Professor 𝗪𝗲𝗪𝗀𝗀𝗀𝗀. So to begin, I think you're the right person to begin with the discussion. From your contribution to the book about Dr. 𝗪𝗲𝗹𝗪𝗀𝗀, normally the death penalty, you wrote a chapter on the most serious crimes, and normally the death penalty is imposed on the so-called most serious crime. So just to lay out the questions to you, whether should there be a common interpretation in ASEAN, and if so, what should be the common interpretation? So with this, I give the floor to you.
Thank you very much, Ajaran Pawat, and thanks to all of you for joining us today. I would like also to join our Dean to thank Ajahn Abara and Ajahn Seri for being here. as our keynote speaker and closing, speech at the end. Of course, I would like to thank all my colleagues at Faculty of Law, Chula University for making this particular series possible. In fact, without their support, it would have been very difficult for us to be here sitting on the panel. And lastly, I would like to thank my colleagues, all contributors who have actually contributed to this book. I was not alone doing this book, but I was working together with Mark Capaldi and Alan Collins, who unfortunately could not join us today because of some particular problem. But we have some other contributors joining us as well. One thing that I should not forget is actually the funding for research for this particular book came from University of Swansea. So we thank them for funding not only the book, but also the launch today as well through the Institute of Human Rights and Peace Studies at Mahidol University. As Dr. Seri has already mentioned, when it comes to right to life, we can look at right to life in a broad sense, not only in the context of death penalty. And I think Dr. Seri has outlined very clearly already. So my talk would be focusing on what it means by more serious crimes and how it has been interpreted in ASEAN countries, how it has been practiced in ASEAN countries, and whether or not, as Ajahn Pawat has already mentioned, we could come up with a common understanding, a common interpretation to come to more serious crimes. If you can go to slide, you can see my outlines already. Right to life and capital punishment, and then more serious crimes, the international threshold, and concept and problems around various interpretations of more serious crimes and the conclusions. In fact, I also put some recommendations at the end. Next slide, please. I will not be going into detail because Dr. Seri has already shown you that right to life was or is still, recognized by Article 6 of ICCPR. And some of you who are sitting here, I think have already studied ICCPR, but just want to emphasize that ICCPR Article 6 recognizes right to life. But then in the same time, so right to life in that particular context is not really absolute, because this could be taken if, as Dr. Seri has mentioned, that the way of taking life is not arbitrary. And I think this is something that we have to discuss further. It's said in the same article, the sentence to death may be imposed only for the most serious crimes according to law imposed at the time of the commission of crimes. I put it here, the last point that you can see in the book, and it was written by one of our editors, Alan Collins, when he wrote in the book, when the publisher asked for some particular sentences, and he said the inhuman and cruel punishment of death undermines the basic rights to life that should be cherished. In a region that is witnessing the resurgence of its youth, our thoughts and prayers are with those and their families blighted by this state-induced brutality. So there are a few things there in what I just mentioned. The first one is actually capital punishment is a brutality. Secondly, it denies the basic right to life that we all cherish. And the third one is inhuman. So I just want to emphasize here. Next slide, please. Why more serious crime came into this book? Because we were commissioned by the AISHA, to do a research project some years back before COVID-19. And it was right to life in the context of death penalty. Of course, our mandate was much narrow. After we submitted the report, including the regional synthesis, it was not well accepted by some particular representatives of 𝐴ISHA, because they said, you know, we went beyond our mandates, our obligations, because we were quite critical. But then what I wanted to say was that we were actually motivated by that particular study for 𝐴ISHA, which was not published on 𝐴ISHA website yet. And we identified some particular issues which demand further research and discussions, especially an open discussions on this particular sensitive issue, because death penalty is considered sensitive in so many countries, especially in this region. For example, the issue of deterrence that Mark Capaldi will be talking about, and of course, you know, more serious crimes. As you can see in the slide, there is a kind of international threshold, although the term or the concept more serious crimes have not been properly defined or not defined by international law. But as I already mentioned, that capital punishment is not completely prohibited under international law, and I already point out Article 6. Its imposition is only permissible if the nature of offense satisfies the category of more serious crimes, and I put it there, you know, in bold, and proper judicial procedures meet the standard requirements based on especially the due process of law, the right to fair trial, and its conduct pursuant to a final judgment rendered by a competent court. I put this with purpose, in the sense that I think there are always many questions about sentencing someone to death penalty, whether or not the due process is there, whether the court is independent enough, whether fair trial is there. So there are many questions when it comes to handling of sentencing someone to death penalty. As I already mentioned, the concept or the term, the more serious crimes, are not specifically defined. So I would not repeat that the committee, especially the ICCPR committee, have already came up with the general comments. It said that more serious crime must be read restrictively to mean that the death penalty should be a quite exceptional measure. And this is an important expression which says a quite exceptional, you know, measure. It means that rendering someone to death must be an exception, and the rules is of course right to life. In countries, you know, which have not abolished the death penalty, capital punishment may be imposed only for the most serious crimes. It being understood that the scope should not go beyond international crimes with lethal and other extremely grave consequences. And this is from the General Assembly. And it includes the offenses that do not lead to loss of life from the imposition of the death penalty. So it becomes a bit clearer, you know, from the interpretation made at international level. In the same time, not in the same time, but later, the Human Rights Council, you know, came up with affirming that the death penalty should only be used for the most serious crime of murder and all intentional killings. So you have another aspect coming in, which is about intention. But of course, you know, at the court, it's so hard to prove whether it's intentional or unintentional when it comes to killing someone. Still, international laws always, give space to state parties to interpret the different concepts and terms in international law, international human rights law. Next slide, please. This is not my compilation. I have to give credit to Mark, my colleague, who actually, based on national reports that we receive from ASEAN member states, members of ASEAN, compiling this into a table. This was done by Mark, and you can see that there are quite a large number of crimes which are eligible by retentionist countries for death penalty, ranging from drug offenses that all countries, you can see all 8 retentionist countries still keep, drug crimes, treason, national security, military crimes, war crimes, genocide, crimes against humanity, or offense against state. There are many things there, not only more serious crime. Even more serious crime at ICC and ICJ, they do not apply death penalty out there. Murder, firearms, kidnappings, corruptions and bribery, robbery of state assets, arson, rape of children, or use of children, chemical weapons, and certain offense against Sharia law. So you can see that there's such a variety of offenses, which, as I said, are eligible for the application of death penalty in 8 retentionist countries. In my paper, next slide please, I focused on assessing 3 types of crimes. The first one is actually about drug-related offenses. So all retentionist states in ASEAN apply capital punishment, as I said, to a number of crimes. But then 3 categories were studied, as I mentioned. The first one, all retentionist states impose the death penalty for drug-related crimes, which are actually called war on drug. And it was, in fact, the origin of war on drug was from Thailand, and it was actually replicated in some other countries, especially the Philippines, for example. The second crime that I examine in the book is in all ASEAN member states, retentionist states I mean, where the death penalty remains, crimes against the state and military courts prescribe capital punishment. And the third one, death penalty could be imposed on economic crimes as well. So including bribery, corruption of public officials, investment and public funds, currency speculations, and the theft of large sum of money. So, of this number, at least 4 of ASEAN member states are imposing death penalty, and you see that it's in Indonesia, Laos, Thailand, and Vietnam. Next slide, please. What are the concepts? I delve into the concept behind the application of capital punishment on various crimes and various interpretations of more serious crimes in this region. The first one is actually, among others, there are 3 key considerations, at least, which was written in the book. First, the seriousness of the offense. in terms of harm that offense will cause to the victim and to the society. Second, how frequent or widespread of offense is. And third, the need for a very high degree of deterrence. These considerations are considered in totally. This is not my statement. This statement was made by the Singaporean Minister of Home Affairs. It was in 2021. In fact, what we found out that there are some common rationales behind the application of capital punishment in ASEAN member states. The first one, reference to state sovereignty. In many interviews made by different retentionist leaders, at least at Ministry of Interior, Ministry of Foreign Affairs, it says that the application of death penalty is a sovereign nation's prerogative. So the sovereignty right of all countries to develop their own legal system, including determining appropriate legal penalties. So it's about the issue of sovereignty. The second one, we saw the predominance of retributive justice concept. So usual justification for the death penalty focus on retribution and are based on the idea that those who committed wrongdoings, especially acts deemed serious, deserve to be punished even to the point of being executed. So this is the second one. The third concept is actually about these, some offenses that you saw on the list are considered as harm to the society. So the concept of prevention is expanded to preclude harm to the society by imposing the death penalty on offenses not resulting in loss of life, such as drug-related crimes. So any breach of law represents a threat to the order and functioning of the society. As I said, is behind the concepts. And this is based on utilitarianism theory of justice. And the last one, concerns of power. In all countries that we examine, the death sentence is seen as a vital aid, vital support to protecting national security. So accordingly, national and state security is often correlated with the security of the country itself, and also, actually to the extent to the security of those in power. Non-democratic governments are actually more likely than democratic governments to use capital punishment. So these are the concepts behind the use of death penalty for the so-called more serious crimes. Next slide, please. I'm concluding, my talk, and I think I spent more than 10 minutes already. The conclusion is, first of all, no one is suggesting that, murderers or drug traffickers are not criminals. They are criminals. But no behavior or person is inherently criminal. And I want to emphasize that no one is inherently criminal. They become criminal only when defined as such by political authorities. The second one, and this is the question, is the death penalty a proportionate and justifiable measure in the fight against serious crimes, especially when legislators stay beyond the internationally intentionally permitted by more serious crimes. So these are the question. I want to finish by quoting the Justice Muhammad of the Constitutional Court of South Africa. and he said the death penalty sanctions the deliberate annihilation of life. It is the ultimate and the most incompletely extreme form of punishment. It is the last, the most devastating, and the most irreversible recourse of criminal law, involving, as it necessarily does, the planned and calculated termination of life itself, the destruction of the greatest and most precious gift which is bestowed on all humankind. So I think this is quite not only interesting but really not theoretical, but there are some concept behind this particular quote that I just made. And I think I have another slide which is about recommendations. Yes, so I put here 5 recommendations. Maybe not much about trying to find, because I could not find common interpretation, and it would be very difficult for introduce this to ASEAN. But I see, if that ASEAN can make a positive contribution to the protection of right to life by first of all, because mitigating factors in ASEAN are still absent in all retentionist countries, so at least mandatory capital punishment should be completely removed, because some countries are still making death penalty mandatory. So this is the first one. The second one is for ASEAN member states to take all measures necessary to ensure it is limited to the more serious crimes, such as acts carried out with intention of killing, but as I say, it's difficult to prove. The third one, ASEAN should provide platform for informed debates on issues relating to the death penalty and what constitutes the most serious crimes in ASEAN and ASEAN member states, to construct a common basis for the region. But I think, in the paper that I wrote, provide some kind of parameters already, what it should mean by more serious crimes. And then to undertake research to establish whether the different offenses eligible for capital punishment currently actually contribute towards the management or reduction of that crimes act, something that Mark will be talking about later, and encourage a shift from labeling and categorizing crimes and corresponding punishment to analyzing the reasons why people commit crimes. So I guess I stop there. Thank you.
Thank you very much, Dr. 𝗪𝗲𝗪 for your input. Mainly she mentioned about there's a collection of crimes and offenses that are subject to death penalty, and she mentioned also about the conceptual elements behind the the prescription of the death penalty on certain offenses, and also the rationale for the retention of the capital punishment, be it the security, be it the harm to the society, be it it's giving the high degree of deterrence for future possible offenders. But the questions we now ask the floor today is that are those rationale justifiable, or are those rationale always justifiable, and is it actually serving its purpose of deterrence? And that leads very fittingly to the next speaker, Professor Mark Capaldi from the Institute of Human Rights and Peace, Mahidol University, who wrote a chapter on the deterrence, whether the death penalty is actually serving its purpose as a deterrence to crime. So, Professor Mark, the floor is yours now.
Thank you very much, Dr. Pawat. If we could have my PowerPoint up. Well, firstly, let me start by thanking Chula University, the Faculty of Law, for hosting us today, And also special thanks to Dr. Amara and Dr. Siri for supporting this initiative. In particular, Dr. Siri, when he was the Asia rep, was the instigator of this project, and he commissioned us to do the initial research, which has evolved into this book. So I'm going to be talking about the death penalty as a deterrent, because this is actually the most cited argument for its retention in the ASEAN region. This region likes to be seen to be tough on crime, and the death penalty as a deterrent, it's felt, would contribute to stability and security within states. So, but what we need to do is question, is this true? And that's really what I'll be talking about briefly today, and there is a chapter in the book on that. So I've just first put here what are some of the fors and against the death penalty from the perspective of the death penalty as a deterrent. So on the for side, the pros, you know, the basic argument is clear, that it is the fear of pain, the fear of death, which acts as a deterrent against crime. And we'll unpack that to see can that argument hold. Back in 2019, in the Philippines, a country which has abolished the death penalty, but there were talks during the Duterte regime of bringing it back. And one of the senators went a step further by saying not only should we be bringing the death penalty back, but we should have public executions. The argument there being that public executions instill the fear of God into people. And so public executions actually act as a deterrent. Another argument often used is that life imprisonment is expensive, and that it would be better that the money spent is used for the families of the victims. Again, this is untested, and in fact, actually it's untrue, because in many countries where there have been studies, economic studies looking at the death penalty, the cost of the appeal process for prisoners on death row, and you know, as the case works up the criminal system to the highest level in the land, actually the cost is much more expensive than life imprisonment. As I say, it supposedly helps maintain public order and stable political structure, and there is research which exists that says the death penalty is a deterrent, and again I will come to look at that. Against, public opinion is not well informed. The research shows that if you carry out surveys amongst the general public on whether they support the death penalty, whether they think the death penalty is an effective deterrent, it very much depends on how you phrase the questions as to what sort of answers you will get. It also depends upon what's happening in the media, in the news at the time. If there has been a horrific case of murder or child sexual assault, then chances are public opinion will feel much stronger about the importance and purpose of the death penalty. So, public opinion, we have to question that. Death penalty for political crimes and terrorism can actually create martyrs, and we've seen this in the case of certain terrorist acts around the world. Another important argument that is used primarily as against the death penalty as a deterrent is the religious and moral beliefs. But I had to put a question mark here because in many cases it depends upon the interpretation to the religious doctrine that is being looked at. I think most of us know that within Islam that is the religion that perhaps is the most accepting of the death penalty, and it is there actually prescribed in Sharia law. Although even within Islam, the focus on forgiveness is meant to be very strong. Within Christianity, you don't have to look very far in the Bible to find cases of, a tooth for a tooth, an eye for an eye, a life for a life. The most famous individual in the Bible, Jesus Christ, was put to death. So many people will argue that in the Bible there was support for the death penalty. And it was actually not that many years ago when the Pope finally came out and said, no, Christianity does not support the use of the death penalty. Buddhism is generally recognized as the one that is most against the use of the death penalty. But again, there have been interpretations and use by certain monks arguing for the use of the death penalty in certain cases. So again, it's to do with interpretation. But what the research actually shows is there is no conclusive evidence-based research that can say that the death penalty is an effective deterrent. So if we look at some of the issues here, and a number of these have been covered so far, the main one then, if we're talking about evidence-based deterrent, is the poor use of the data. In some cases, the data may not actually exist. So in Vietnam, for example, the use of the death penalty is a state secret. For other countries in our region, the information on the use of the death penalty is not necessarily public knowledge. Also, there are grave concerns over weak statistical models that are used by researchers. And as you look at the different papers, you will find there is no consistency in how data is being analyzed and which variables are being used and examined. Crime cannot be looked at from the perspective of unitary measures. Crime is very, very complicated. And what you find is that researchers tend to use different models. So papers and research is not comparable in that sense. I should also have said that there is a huge dearth of research on this issue. Most of the research around the use of the death penalty as a deterrent is actually US-based. I could only find one study, which is now more than 10 years old, which looked at a comparative study, which looked at comparing Hong Kong with Singapore, because they were felt socio-economically to have some similarities. But even then there are difficulties. How in depth are you looking at understanding crime, understanding the police systems and the effectiveness of law enforcement in a country? So because we're talking to primarily students and academics today, I thought, okay, I'll put up some people that you may be familiar with, historically that is, from the Enlightenment. Although Dr. Siri has put me to shame by actually putting up a former king of Thailand from the 13th century. So here we're looking at the Enlightenment philosophers from the 18th century, which was during a time of great brutality within Europe, where there was horrific torture taking place all of the time. The death penalty was given out just like that. So the Enlightenment thinkers came along at a time where they were questioning the use of certain reasoning and logic and skepticism. And these handsome individuals here were the ones that started to look at issues related to the death penalty. John Locke, looking at natural law. Rousseau, looking at the social contract and discussions about what individual human rights is acceptable to give up to the state so that the state can maintain stability and security. Immanuel Kant was a supporter of the death penalty, but he was very clear, not as a deterrent. He was a supporter of it for retribution, for severe punishment for the most serious crimes. But the person who really studied the death penalty the most was Cesare Beccaria, the Italian philosopher. And it just amazes me that at the age of 25 years of age, he wrote this book on crime and punishment. And he said on the death penalty, "It seems absurd to me that the laws which are the expression of the public will and which execrate and punish homicide should themselves commit one, and that to deter citizens from murder, they should order a public murder." And he really, in this book on crime and punishment, made it very clear that the state has no right to apply torture or the death penalty. He argued that within the social contract, the right to life is the most important right. It's the biggest of all of the rights, if you like. It's not some small right that can be taken away. And that's what the social contract is about, is looking at the smallest of rights that can be taken away. And of course, he also talked about how the death penalty and executions brutalize society. So he came up with a number of theories around deterrence. And many of these, of course, and the reason why I wanted to emphasize it, is they are still relevant today. And so it's a sort of rather sad reflection of how we have moved on. So he talked about the certainty of punishment and that should take priority over the harshness of punishment. And this is a key theory around the use of the death penalty as a deterrent, that it must be certain. If the punishment is not certain, then it is not actually going to be a deterrent. If a punishment is not swift, it's not a deterrent. And when we look at how the death penalty is used in ASEAN, these principles of swiftness, of certainty, are not actually followed. The harsher the punishment, the more likely the criminal will commit more crimes to avoid it. There's plenty of data that shows that criminals will actually murder the victims of their crime in order for there to be no witnesses, so that they feel that they will actually have a better chance of getting away with the crime if the victim is not around. So the brutality of punishment will adversely affect the savageness of the criminal. Attempts should be punished less severely than a completed crime, and thefts without violence should be punished with fines. So how does this relate to modern day use of theories? Obviously the deterrence theory being that, as I said, the fear of death. That's basically this rationale, the rationale theory, the rationality that if people realize that if I commit this crime, I could be executed, they will therefore not do it. But I think we've all heard of crimes of passion. Many crimes take place without the perpetrator thinking clearly. Many crimes take place where the criminal is under the influence of substance abuse, alcohol, drugs, particularly around drug trafficking crimes. So are these criminals thinking rationally? No. So that argument may not hold. Many countries in the region have moratoriums on the use of the death penalty. The 𝗪𝗲𝗪𝗲 hasn't used the death penalty for, I think, about 35 years. Brunei last used it in 1959. So if the argument is the death penalty acts as a deterrent, if you don't actually carry out any executions, then that argument is not there. Not that, of course, we are saying you should therefore use it, like Myanmar has. And that's obviously why Myanmar has started to use the death penalty, is that they feel that it will act as a deterrent against civil unrest and protests. The theory of crime says that crime is actually a normal part of society, and that as it's there, then you need punishments to ensure stability and security. But again, as I've mentioned, this can lead to the silencing of victims and the brutalization of society. And then the last one, economic theories of deterrence, the sort of opportunity cost of doing a particular crime, which in the case of drug trafficking, for example, has been clearly seen in the ASEAN region not to be deterring drug trafficking and drug-related crimes. So to conclude, you can find research which supports either argument, pros or cons, in around the use of the death penalty as a deterrent. So it's not possible, you cannot just select the ones which fit your argument. Public opinion is unreliable, and the public opinion in politics tends to fuel each other. It's sort of like a cycle. And capital punishment related crimes remain high, as can be seen in the ASEAN region. So ASEAN countries perhaps should be looking at the alternatives. For example, life without parole. And we need more comparative studies to look at, say, life without parole compared to the death penalty. So this can help us to look at, are there better ways? So to end with, my conclusion would be, and if you were studying this academically, it's to say that the hypothesis that the death penalty deters serious crime cannot be factually supported, and so should not be used by the politicians and others as the justification to retain the death penalty. Thank you very much.
Thank you very much, Professor Mark Rapaldi, for your insights on whether or not the death penalty actually served its purpose as a deterrent. He led us to explore the pros and cons of the death penalty and concluded there's no conclusive studies that the death penalty is actually a deterrent, because there are not many data publicly available, the poor usage of data, and the research is not comparable because there are many instances in different contexts. He mentioned that I was intrigued by, he mentioned that Beccaria wrote his theory at the age of 25. At the time, I was just finishing my master's degree. So very impressive on Mr. Beccaria. Well, so to sum up on his findings, because there are conflicting evidence, because there are conflicting data, because there are conflicting theory, the terms conflicting itself actually says that because it's that actually point out that to us that the purpose of deterrent is actually not conclusive. But when the consequence of having this punishment affects the right to life, therefore I think we need more research and more comparative, methodologically correct research analysis to actually unfold this justification. Let me turn on to the next speaker from the Philippines, Professor 𝗪𝗲𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀𝗀😊 Are you with us in the Zoom? Can you unmute your microphone? We still can't hear you. Oh. Can you repeat?
Hi, can you hear me?
Oh, yes, very clearly now. Oh, thank you very much, Professor 𝗪𝗲𝗀𝗀𝗀𝗀𝗀, for agreeing to be a panelist on this academic seminar. And a warm welcome. Too bad we can't welcome you in Bangkok, but hopefully you'll come visit Thailand anytime soon. Right. So, in your let me ask you based on the chapter that you wrote in the book, because you wrote on the authoritarian regimes and the media and how they shape the public perception and support for the death penalty in ASEAN. So I would like you to talk about how the media itself actually played the role in gearing up or shaping the public opinion on whether or not supporting or not supporting the death penalty, and especially with possibly with examples from the Philippines, your country, and Cambodia, based on your research. Thank you.
I'm hoping you guys can see my PowerPoint.
Yes, very clearly.
All right, so good afternoon, everyone, and thank you again to the organizers in Chula for allowing me to share this with you from Manila. As mentioned, one of the chapters I contributed to the book looked at the ways in which authoritarianism and the media affect public perception and support for capital punishment in ASEAN, outlining the tenacious and often perplexing support for the death penalty in the ASEAN member states. In Malaysia, there have been recent positive developments in the area of mandatory death sentencing. We recall the push for complete abolition in 2018, reflecting immediately after a good number polled as being opposed to such abolition. And in the same year, Singapore also reported very strong support for their current policies with the death penalty. And the same story was also reported in populous Indonesia, the Philippines, Thailand, and Vietnam, with politicians often citing public opinion and support. Now, be that as it may, legitimate questions have been raised over the basis of the popular support and the possibility that it is in fact overstated. Concerns have been raised regarding sample sizing, for instance, or the methodologies employed, the framing of the survey questions, etc. If you recall, a few years back, perhaps 10 years back, Professor Roger Hood had undertaken a study on capital punishment in Malaysia. And at the outset, majority of the respondents had appeared to support the death penalty in theory. However, when details were shared and respondents asked to confront specific cases, opinions markedly changed and support for execution dropped. And since then, similar surveys subsequently done even in Singapore and in the Philippines in the last few years have provided comparable conclusions. In any case, public support may be more apparent than real. generalizations or simplistic questions impair the health of the debate, if you will, as there are complex aspects to the discourse, such as support for mandatory death sentencing, and there's a lack of awareness of key factors. For instance, the rate of wrongful convictions. Before the abolition in the Philippines, for instance, the rate of wrongful convictions, our Supreme Court found, stood at about 72%. So, you know, there's a lack of awareness of these factors on the part also of those who are asked for their opinion, so to speak. Now, let me just touch on the attitude of regimes in the region as to capital punishment. Amnesty International has pointed out that strong public support for capital punishment is often associated with and linked to a lack of reliable information. And important factors on how the death penalty is applied are often not fully comprehended and considered in formulating an opinion. Such information, particularly in ASEAN states, which claim that national security concerns do not allow it to provide full access to data on implementation, is not usually available to the general public. A full debate, therefore, it can be argued, is inhibited and constricted absent the required transparency. But Amnesty International has also posited that the decision to execute someone cannot be decided by public opinion, and that governments must lead the way. Now, whether governments in ASEAN can or will lead the way, of course, is another question altogether. And in recent times, disturbingly enough, most governments in ASEAN have settled, if one were to subscribe to the whole authoritarian democratic dichotomy, most governments in ASEAN have settled on the authoritarian side of the spectrum. And the common thread found in authoritarian regimes is the bannering of policies that are supposed to be tough on crime. Resort is made to simplistic and sweeping messaging on the death penalty being an effective deterrent, I should say, on public support being in favor of the death penalty, and on capital punishment as a hallmark of public order and being serious about crime. The more evolved surveys of recent times, however, show that the much touted public support is not unconditional nor unnuanced. When details are given, when sentencing options are provided, when due process violations are brought into the picture, opinions can and do change. The problem, though, is that data and information on matters surrounding actual cases are hard to come by. Lack of transparency, lack of access to the defendants, difficulty in getting official data, absence of freedom of information law. These are just some of the factors in the opaque picture of the true state of affairs, even in countries which do not expressly disallow access to information per se. So let's talk about media. The interplay between the issue of capital punishment, authoritarianism, and media is by no means a simple one. Professor Bandis has observed that law and media exist in a complex feedback loop. And precisely the way these two concepts react and interact in that loop is affected by even more variables undoubtedly in the mix, such as the state of media independence in such authoritarian regimes, the perceived newsworthiness of issues involving the death penalty, and the importance given to media by those in power, whether executive or legislative, those who come up with the legislation. And it also bears noting that authoritarianism has historically had a very hostile relationship with free press. And in a region that is currently pocked with authoritarian markers, the outlook is not rosy at all. In the 2023 World Press Freedom Index, for instance, which is an index of 180 countries, the only ASEAN state which broke into the top 100 is Malaysia at 73, or the 73rd. And 2 of those in the bottom 10 are actually from ASEAN, Myanmar and Vietnam. Vietnam actually in the bottom 3. So this is the picture. Media is heavily state-controlled in several countries, and even in countries where the press is ostensibly independent, there are current major challenges brought about by increasingly authoritarian regimes which view a free press as subservient to their version of public order and security. In the Philippines, for instance, journalists are being red tagged if the messaging is not really pro-government. If there is, if there is opposition, then it seems as if that in itself is already worth red tagging journalists who are actually independent. Then because of this, when dealing with media coverage of capital punishment, the influence of government in terms of messaging cannot be underestimated. And when the government in question is authoritarian in nature, with an overall policy of communicating the message that it is tough on crime, coupled with the existence or the insistence that capital punishment is an effective deterrent, as was pointed out by the previous speakers, the input into public education, whether expressed or subtle, is decidedly pro-death penalty. The answer to the query of whether media really affects the way the public views current events and issues seem rather obvious. For good or bad, media does not only report, but it actually defines. Professor Bandis has pointed out that media and its aspects have significant implications on the delivery of justice, since most of what the public knows about the criminal justice system does not really come from direct experience, but from, let's face it, media portrayal. Moreover, it is not only individual opinions and social relations that are affected, but also political movements and government policies because of the feedback loop. Information about death penalty cases can be hard to come by, so what may be considered as verified fact for news depends on what the authorities deem proper to share. So conditioning over time, if you think about it, is not a far-fetched supposition. Authoritarianism affects and utilizes media coverage of important issues in ASEAN jurisdictions. Media coverage, in turn, creates and influences public opinion, and public support then gives a semblance of legitimacy for authoritarian messaging on the need of the death penalty as a crucial deterrent to crime. And so it is, in fact, a loop, one which hopefully can be disrupted on a number of fronts. So at this point, just allow me to proffer 3 points and observations that entertain possibilities. In the study by Dardis et al. On media framing, the authors wrote of the advent of a novel conflict-displacing innocence frame in death penalty discourse. And this is in the US, but it's also perhaps relevant to us. And this discourse highlighted the imperfections of the criminal justice system, and they wrote about how this new frame made much greater impact on individual responses, resulting in a decline of public support for capital punishment. And whereas previous frames potentially reinforced those who already had a position on the issue, the innocence frame, they observed, does not ask those who are opposed to it to reevaluate their own religious or core moral background and values. Rather, this new frame simply asks people to focus on the question of whether a human-designed institution processing thousands and tens of thousands of cases can be expected to do so perfectly without a single error. So the value, of abolition advocates and media partners perhaps cohesively strategizing and working on angles that amplify miscarriage of justice and the innocence frame, maybe it has already been explored and employed, but perhaps this can, benefit from a resurgence of focus. Secondly, a survey of the situation shows authoritarian strangleholds, if you will, on more traditional media in the region. While it is by no means suggested that the fight to hold the line when it comes to press freedom in whatever platform should ever be given up, exigencies may also require that social media be optimized in strategizing for abolition advocacy. The internet has become a convenient alternative if we're able to use it optimally. As of 2022, for instance, 8 of the 10 ASEAN states had more than 75% of their citizens online, while the remaining 2 had at least 50% on each online. Studying how social media tools can be optimized can be a priority, especially as the rate of users in the region has increased rapidly. And thirdly, fairly recent surveys have churned out revelations about the level of awareness which our citizens have on the capital punishment issue. And the majority of the public whose support is often flaunted as a key factor in retaining capital punishment appear to know very little about the factors that surround it. Continued public information dissemination on the state of death penalty legislation, as well as application, can contribute to challenging the government's sound bites on the state of public support in the media. And with any luck, this will inform and shape elements that go into the law and media feedback loop. Ultimately, the ways authoritarian regimes and the media shape public perception and support for capital punishment in the ASEAN region cannot be taken for granted. I wish I could say more, but I did write a lot more in the book. But hopefully these insights and observations may prove helpful in continuing the efforts to assert the right to life. And I do hope I haven't gone over on my allotted 10 minutes too much. Thank you very much.
Thank you very much, Professor 𝗪𝗲, for your insights, information, and observation on the how the public perception can, how the media can shape the public perception on the death penalty. And you interestingly talked about how especially in the authoritarian regime where, the censorship and government influence actually play a role. And this is actually the interplay between the freedom of expression and the right to life. And you rightly, because nowadays we are in the age where everybody can be a content creator. So this is actually a disruption to the traditional media outlet that you mentioned. That maybe the social media and the age of internet can counteract with the traditional media outlet that often define or interpret the news rather than simply reporting the facts in the news. So thank you very much, Professor 𝗪𝗲, for your input and information. And don't worry, I think with your presentation, I think everybody wants to read more on the book. Okay, so thank you very much, Professor 𝗪𝗲. Now let's move to the last speaker of this panel discussion. We have Professor Edmund Bon Thai Soon. He's a former Malaysian representative to the AISHA. Very honored to have you with us, Professor Edmund.
Thank you very much. Can you hear me?
Yes, very clearly. So thank you very much for accepting our invitation. And again, too bad we wish to have welcomed you on site, but hopefully sometime soon. Professor Edmund, Given that, given your expertise on the regional level and your experience at Aisha, what are the regional trends of the death penalty in ASEAN, and what should be done about them?
Thank you very much for the invitation, and congratulations to Ajahn 𝗪𝗲𝗯 and Ajahn Mark and Professor Alan for the book, which I've gone through a few hours ago. Actually, it's a very good, comprehensive book that covers the region. Just a few comments, and just to respond with some observations on the question that was asked. First of all, I'm not a professor, so don't label me that. But I wanted to just make a few comments about the book and how the book presents the regional perspective of the death penalty in ASEAN, and then maybe talk a little bit more about how I think in Malaysia recently we have been able to move ahead after some stops due to the change in government a few times. The book, I think, represents a good message that is being sent to ASEAN member states, that we should not be afraid of examining and questioning the reality of our criminal justice systems in the region. Even as the issue has become so controversial and politicized regarding the death penalty, and as I highlighted just now, the AICHA was not able to finalize this report in the thematic, shows that there is still a lot of sensitivity around the issue. State sovereignty is still frequently invoked, and it seems to have become a paralyzing force that is preventing us from defining our own human rights standards and to monitor our implementation. Regarding, for example, the definition of the most serious crimes that was explained by Ajahn 𝗪𝗲𝗯, even that kind of discussion is lacking, and we see that in Malaysia, even as you want to define and move away from the death penalty, how the most serious crimes is being defined or looked at by government and by public opinion is still very nascent, is still very new. So that kind of discussion and further research needs to be done. But I want to be more optimistic here and say that in a more traditional, in a more non-traditional sense, the advent of social media, among other factors, has revolutionized who controls public debates. You can see how high-profile cases in the different countries has significantly contributed towards shaping government legislative agenda. So how a lot of the cases that have been highlighted by NGOs looking at the unfairness, and even the cases in Singapore, try as I think the governments like, but the cases of how the poor young drug convicts for trafficking, their cases, how they have been highlighted, has revolutionized the discussion about the death penalty. So I think Professor Maita mentioned about the impact and power of the media. That tool becomes more popular and becomes something which can be used a bit more often in highlighting the cases that have been coming before the courts, and the unfairness and unjustness of the death penalty. In the more traditional sense as well, authoritarianism and the media, while affecting public perception and support for capital punishment, debunks a lot of the public opinion argument. We see how governments invoking the results of a public opinion survey to justify executions and their highly punitive death penalty policy. But repeated studies have shown how public opinion surveys can be influenced by the timing of the polls, the methodology, and how the public opinion surveys should just be considered as a temperature check. It shouldn't be definitive. And public education, more public education needs to be done about the human rights dimension of the death penalty, which really takes us back to the role of the ICHA and regional bodies and ASEAN in how it can advance a conversation, given that the 2025 year end, the strategic framework is ending in 2025, and another 10 years needs to be drafted for ASEAN to work on human rights in ASEAN. I think we should also not forget that in several ASEAN countries, efforts by activists to raise awareness of the multifaceted realities of the death penalty can be met by harassment and cracked down by the authorities. We have seen many examples of activists being taken to the police or charged or given formal warnings after exercising their right to freedom of expression. We should not forget that the fight against the death penalty relates and is interconnected with other rights as well, and not forget the efforts and the strong advocacy by the many activists in the anti-death penalty circle. Which brings me to my second last point, which is transparency. There's still too little information publicly available in our region, and some of the book chapters mentioning, I think Ajahn Mark mentions it in his chapter as well. In some countries, we see some partial information being published. For example, Singapore publishes once a year figures on executions, and executions are only one aspect of the death penalty. We need more comprehensive figures to inform the public and empower stronger debates and understanding of the issue. Without comprehensive figures, not only the extent of the resort to the death penalty will remain unknown, but it also makes it possible to start an assessment of the discriminatory impact of the death penalty and how that interplays with ensuring that the right to a fair trial is fully protected. Finally, the death penalty abolition has to be part of a comprehensive package of criminal justice reform and human rights assessment. So in Malaysia, we outsource, or the government outsource the assessment of the death penalty to committee led by the former Chief Justice, and while the committee had done a lot of consultations, that kind of method where it's sent to a committee of experts seems to be a preferable route in Malaysia, because it was very difficult for retentionist activists to argue against such eminent panel of jurists on that committee. However, public opinion also mattered, and the government said that it was not going to abolish completely the death penalty, but just the mandatory nature. However, what I think we forget is in that whole package, the death penalty was in fact abolished in 6 offences. So while the government said that it was only going to abolish the mandatory death penalty, which it has now done, and is going to re-sentence 1,000 over prisoners, there were 6 offences where the death penalty was completely abolished. So that whole package must come, and it came as well with how natural life imprisonment in Malaysia has now been removed. There is a limit to life imprisonment. There is attempts to review our legal aid system. There is also new laws that have been put in place to look into parole. So that ongoing discussions have to be complemented, and it works together as part of a package. So a step-by-step approach is really the most appropriate strategy for our region. And the discussion, I think Ajahn Sri Papa mentioned in her chapter, let's talk about abolishing the mandatory death penalty first, and then move on as we go along. And I think there are some case studies, and Malaysia is one that has come into fore. Thailand as well. Indonesia, the new criminal code where death sentences will be allowed to be commuted after 10 years. We have also seen the death row cases in Thailand shrinking after repeated commutations granted by the king. And of course, the perception of abolition being an imported concept from Europe needs to be factored in as well. The whole argument about cultural relativism and Asian values still prevails in this region. And we need to look not only to Europe, we need to look at what Africa is doing, the African Commission, through its working group on the death penalty, and then compare and perhaps learn some lessons for ASEAN activists and the 𝐂𝐡𝐻 to take away in its continuous work to abolish the death penalty. Thank you. Those are my observations for the moment, and return back to the panel.
Thank you very much, Professor Edmund, on your observations on the recent developments of the regional trends in ASEAN on death penalty. So I think we still have a little bit of time left. Any questions from the floor? Yes, please. Please introduce, state your name and then your question.
Hello, good afternoon. Thank you for the panel for the insightful discussion. My name is Alexis Nadine Bautista. I am a master's student in IHRP, Mahidol University. I'm coming from a perspective of, well, my undergraduate thesis was restorative justice for children in conflict with the law, or more commonly known as juveniles, although that's an outdated term. So I just want to look at from the adult's perspective, because in some European countries, but in Asia, there's Japan and Thailand who has been working or trying to pursue or trying to have efforts to look at restorative justice, which deviates away from capital punishment. I think in Thailand, since 2004, by Dr. 𝗪𝗓𝗪𝗂𝗪𝗓, if I'm not mistaken, who's been pushing for restorative justice for criminals. So, but then in the ASEAN context, do you think is this addressed to anyone who is willing to answer? But do you think it is feasible in ASEAN to implement or at least consider this idea or method? Or is it too far off of an idea or method given the current context or reality with the authoritarian regimes and with the media? So yeah, thank you.
Maybe another question, and any more? Yes, please.
My name is Muhammad Fuiwan. I am the master degree in Chula University in law faculty. I have the question that when you talk about the right to life, or maybe to like the anti-capital punishment, it's like something that comes from the European perspective. Is for my opinion, it's like some kind of white man burden episode. Second, in the way that you use the word that something like the human right, that it look like something that people participate in, create it, but actually from the beginning of the human rights, it comes from the Judeo-Christian tradition, that it comes from the white people that create it. It is not that all people or religion or all belief to create it. In the Asia, especially in Indonesia and Malaysia, people live in Islamic tradition, but you try to use something that called the human right and impose the concept of it to the people. It's like to say to the people that there is something that above above something that people believe that is the supreme. So I think it's just like when we talk about right to life
can
or
you
something.
state your question?
The question is that can we really implement something like that, the right to life concept by the don't care about the way that people believe? Just that.
Question. So we take. I think we can answer 2 questions and then we move to the next session.
Okay. Thank you. Thanks for the 2 questions and comments. I guess Ajahn Mark or Edmund or Maida would be sharing their thoughts as well. From myself, first of all, addressing the issue of restorative justice. First of all, it is impossible to actually introduce restorative justice without eliminating retributive justice, especially capital punishment. Because when you sentence someone to death, you already making their restoration die as well. So there is incompatibility between retributive justice, especially death penalty, and restorative justice. At least, when you sentence someone to, for example, life sentence, there is a chance that the person may be pardoned and can live their life because their life were not terminated yet. So as I said, even one of our PhD students, under Mark and myself supervision from the Philippines, she was working on child rights or the best interest of the child in juvenile justice. I found it very interesting because even the death penalty is not applied to children below 18. Still, the justice system in ASEAN region still focus on retributive justice rather than restorative justice, because in many cases those children were not given chances to actually to live their life based on the human rights. So human rights approach has to be there when you talk about restorative justice. The second one is about, I found your comment, I could not get your name, our master student from Chula University. I think you talk about a few things. A few things include about the fact that, not the fact, that the question whether or not human rights are Western ideas, Western concept. These also include right to life, because right to life is included in international human rights law. I think that's the first one. The second one, whether or not these human rights are being imposed on us as non-Western or non-white. Well, we have someone white sitting there. But I think, as non-white person myself, and white person like Mark Capaldi, I think we share exactly the same concept, the same ideas, and the same beliefs, that we were all born with rights. So my answer is that, first of all, I don't think human rights comes from the West. If you look at the creation of UDHR, actually UDHR came out of participation of all, representatives from all continents, white and non-white, and from all religions as well. So I found it quite interesting. The second one, you are actually, I think, emphasizing on the Asian values discourse, which I think, or I feel, I hope at least, already disappear from this region. But, in reality, the concept of Asian values, which may define or may prioritize human rights, not exactly the same way that we believe at international level. And I think this is, for me, it is dangerous. If you think that human rights and human rights concept come from the West, then non-Western like us do not deserve human rights. And as I said, this is serious, because we all feel, and I always believe that as non-white, as non-Europeans, non-Western, I deserve the same rights as them. So these are, some of my thoughts.
Thank you, Ajahn Sripapa. I'll very briefly add on some other points as we go through the panelists. To answer your question about whether it's feasible or not, the sort of restorative justice approach or argument, I think Ajahn Sripapa has sort of sadly explained why that's not possible. I mean, the areas where I think we can see the potential for progress and to see a movement, a potential movement with ASEAN is, as Edmund talked about, removing the use of the mandatory death penalty. That's a step in the right direction. Another step in the right direction could be, say, as Ajahn Sripapa was talking about, reducing the number of crimes that warrant the death penalty. So, and I've also heard that there's been calls for removing the death penalty for women, for example, because if you look at virtually the majority of women that are on death row, it is for drug trafficking, acting as drug mules, women that have been coerced or tricked into carrying drugs. So these are perhaps more of the sort of realistic steps that might take us in an abolitionist direction. In regards to the second question, I mean, obviously I fully support and endorse what Ajahn Sripapa has said. In many ways, if we want to point the finger of blame to the West and to the white man, I think we can, in the context of where a lot of these penal codes and colonial laws came from. Sadly, we brought some of the legislation around capital punishment to the region. And for certain crimes as well. So I think we can apologize for imposing that on the region. But equally, what's interesting is some of the research has suggested that it's exactly that reason why ASEAN governments are now so resistant to change, because they're almost, it's almost a sort of an anti-colonialist backfiring. They're saying, we don't want to be told by Western countries now about what we should be doing with our legislation and our legal reform. It's for us to decide. So actually, it's become an inverse argument, tragically, that the fact that we brought some of these legal codes to the region is now the reason why countries are not willing to look at the potential for changing them.
All right, thank you very much, Professor Sripapa and Professor Mark, for your questions, and thank you all the audiences for a very... Oh, sorry, I forgot. Any addition from Professor Maita or Professor Edmund?
Thank you. Just perhaps an observation as far as the first intervention is concerned. I just wanted to say that as far as restorative justice is concerned, this is something, as far as the Philippines is concerned, something that warrants vigilance, really, full vigilance, because restorative justice was something that brought up in the discourse in the Philippines quite some time ago. And there are actually certain aspects of the justice system which have adopted restorative justice, not only regarding children in conflict with the law, but also rehabilitation programs, etc. But one takes a look at how the criminal justice system was treated during the last administration, for instance, when there was a real scary push to actually reinstate the death penalty in our statute books, to see that restorative justice has not quite taken root in how our politicians think, in how our policymakers think. All of the bills that sort of were brought up again for the reinstatement of the capital punishment all talked about punitive justice, as if it was still the be all and end all of the criminal justice system. So vigilance as far as the strides that have been made in terms of the abolition of capital punishment in the region, this cannot be discounted, even as we work towards more progress and development in this particular context. Thank you.
Thank you very much. Professor Edmund, any additional comments?
No, I have no additional comments.
All right. Thank you so much, all the speakers, Professor Maita, Professor Edmund, Ajahn 𝗪𝗲 and Professor Mark, for all of your interesting observations on the death penalty in ASEAN. Today, Professor 𝗪𝗲 talks about the crimes and how that there's no common interpretation and the rationale is not there, and the deterrence is not serving the purpose of deterrence, and we see how the public perception can actually being influenced by the authoritarian regime, and also we see a lot of the regional trends of the death penalty in ASEAN from the observation of Professor Edmund. So with all of that, thank you for a very interesting panel discussion. Then we move on to the next session, which is the book launch. So for now, thank you very much for the panelists. Thank you. Okay, so the next session is the book launch of the content that we've been talking about today, the Unpacking the Death Penalty in ASEAN. And today we are so honored to have with us back here again Ajahn 𝗪𝐸𝐴𝐻, Dr. 𝗪𝐸𝐻 𝗪𝗏 from the Faculty of Political Science, Chula University. So the floor is yours.
Thank you very much. So already there are 2 books here. I brought mine. Let's make it 3. But thank you very much, distinguished guests, ladies and gentlemen, for coming to this afternoon. And this is our latest work, Unpacking the Death Penalty in ASEAN. And don't be fooled by its physical size, physical appearance. The book is very heavy. Like the content is very heavy. The topic is serious, and it contains a lot of facts, figures, and many good analysis. And the goal of this book, if you reach the end of the last chapter, definitely this is toward the road to abolish the death sentence. But in order to be able to abolish death sentence, you need to unpack it. So that's the goal of every chapter of this book, to unpack the death penalties from many perspectives. But death penalty is one of the most, I would say, one of the most primal punishment, a form of punishment that human ever understand and experience. It's straightforward. It's easy to understand and something to touch deeply on people's emotion, not only like their experience but their emotion as well, and it ultimately it tests the limit of that society, how you are going to make or to formulate a policy on crime and human rights and human life. So that's the two things. So a lot of oftentimes when you look at policy on death penalty, on capital punishment, in that jurisdiction, you realize that it reflects that jurisdiction's government's view on human, what's like human life is about, basic human nature, whether you can restore that person, that bad person, or you need vengeance, you need revenge for the crime, right? So it's like humans basically good or bad, and also the idea about human rights, whether it's something that that society is willing to embrace, or this is something that society might not be willing to be imposed upon. Also, that reflects something about that society's idea about rule of law, perhaps dignity. There's a chapter on dignity. There's the idea about religion. You know, I'm going to mention about it in details later. But all in all, that I would say death penalty tests the limit of that society. And when you move that topic and fit it in the context of Southeast to ASEAN, Southeast Asia, it makes a very, very interesting case. ASEAN is very diverse in many ways. That sounds like a cliche because everyone says ASEAN is diverse. It's not a big region, but within that region you have religious, you have various ethnicities. You have mainland Southeast Asia, but even mainland Southeast Asia, you have Myanmar, you have Thailand, you have Indochina, and even in Indochina, you have Laos, Cambodians, and Vietnam. They all have their own different background. And archipelago Southeast Asia, you have the Philippines, Brunei, Malaysia, Indonesia, and we are under different. We have different religious orientation. We also have a very different regime. Ranging from absolute monarchy and semi-democracy up to, I mean, sadly, that's one point of commonality in ASEAN. It seems to be like we are not in like a totally free, liberal and free democratic society, right? And we all have and that I mean play. An important roles in forming the idea of death penalties. Many of us were under colonial power, and that colonial history left some mark on their penal system. Malaysia's case in point, majorities are Muslim, and Sharia is applied in Malaysian legal system, but the penal code is very British, so the death penalty is actually take after British, and we all have our own problems when it comes to like what crime we want to impose a death penalty punishment on. So that's the idea of this book when you try to unpack the idea of death penalty in the context of ASEAN, right? And this book is not only about like talking about human rights and death penalty in abstraction at abstract level. I mean it tries to unpack it from trying to look at facts and figures, debunking the myth about the deterrence effect of death penalty, only to discover that actually the deterrence effect is actually not very effective. It's more like a myth, and that actually it would connect the opening chapter to another chapter in this book, the role of media in portraying death penalty. And I mean, although ASEAN shows some progress in recent years, it used to have like very high numbers of capital punishment per year. That number dropped. That's some progress, but still a lot of us, 8 out of 10 countries, we are retentionists. We retained it. Even Thailand broke its moratorium in 2018, right? So that's one thing. And as the region progressed into a more authoritarian direction, the role of media and how the topic of death penalty has been politicized to serve political interests of the leaders are being discussed here. Authoritarian regime and the media and how they shape perception and support for capital punishment in ASEAN. The Philippines is the case in point here, successfully abolished under 𝗪𝗲𝗯𝗪 Arroyo, Macapagal Arroyo, successfully abolished death penalty, only to be threatened to reinstall it under Duterte. I'm not sure like how like Bongbong is doing, but they threatened it in the last government, right? So that's the discussion about fact and fiction, the idea about authoritarian regime and the role of media in shaping people's perception in support of death penalty. Ajahn 𝗲𝗪𝗏's excellent chapter on the most serious crimes and the most serious crimes, which is an offense allowed under international human rights documents to apply death penalty. The chapter discovered that the most serious crimes in ASEAN use a very different standard from international standard. Interestingly, two of the most serious crimes, one is the drug related, and I think that shows like the context that ASEAN, the problem of crime that ASEAN is facing right now is drug. The other is a crime against the state or the government, right? So that's like against the military, for example, and that also shows what kind of society ASEAN is right nowadays. Of course. So that's but not only like all the talk about theories and abstraction, it goes down to like practice. The chapter on dignity of death row inmate and how ASEAN, like we should treat them, like the method of execution, for example, and the effect on the hidden victim, the families, how it affects the families. Usually, I mean, in the region where human right is very weak, the idea of human right is very weak. Even like the process or along the way into the execution is also a punishment in itself. I mean, we no longer like make it a public display, but still like the process make it degrading, inhumane, and suffering as much in agony as much as possible. So that's the chapter covered by Patricia, and also the role of religion. The ASEAN is a very religious region, and here I think it shows something very interesting about the society that claim to be religious. In theory, many of these religions, and when it comes to religions, you compare it to human rights, and you have to realize that religions are something very ancient. I mean, it was there before the idea of human rights, and how it's gonna deal with human rights is very interesting. These religions, they offer both sides of the argument. Religions often talk about love and compassion and forgiveness, but also religion talk about right and wrong, punishment, justice. Right? So you look at religions and you can argue for forgiveness to abolish the death penalty, or you can insist that this is a moral duty to do it, to commit it, and all the three case studies here, I mean, they try to go on to the direction of God of punishment, right and wrong and stuff like that. I mean, Islam is there's one question earlier, but even in Islam, where they have where people think of Sharia as something that very how to put it draconian, but actually if you look into the text is like it lays out a very elaborate and procedural safeguard, very high bar for procedures and for a very specific crime. Only specific crime can have a capital punishment. And on top of that, they say that, but if you have a chance, forgive, because like repentance and forgiveness, that's what God is expecting from you. So even in the case of Islam, you have a common perception that they're harsh and draconian. Actually, there's a side of it. The only question is why they don't go in that direction. Why they go to a retentionist idea. So all in all, there's as I say, like the book, all the chapters in this book, they tackles and try to unpack a very heavy topics in many aspects, media, politics, myth, theories, restorative justice, religions. I hope you guys have a chance to have a look on this, and highly recommend. And I couldn't thank Chan 𝗪𝗲𝗯, Chan Mark, and Chan Alan more for like pulling us together to carry out this project. It was written under the time of COVID, so like all the stress that we have, working remotely, trying to employ it too, but eventually we did it in a relatively short time, and I would say the result is marvelous. Thank you very much.
Thank you very much, Dr. 𝗪𝗏𝗀, for your observations and for the giving us some details about the book. Of course, this book, it illustrates the interconnection between law and policy and all the contributing factors that are being unpacked in the book on how the death penalty is being, observed in ASEAN countries. So thank you very much, Dr. 𝗪𝗏𝗀 for your contribution, and also Ajahn 𝗪𝗲𝗏 and Ajahn Mark. Congratulations for the book. I'm sure that this book will be available in the Law Chula library soon. Since the summer books are here, I'll try to snap it. Anyway, thank you very much again. And I think should we take a group photo now that Ajahn �𝗪𝗏𝗀 is here and Ajahn Ambara is here before we move to the closing speech session? แนนครับเชิญถ่ายรูปครับ All right, so we now at the final session of this today's seminar on the right to life. We are very honored to have with us the current Thai representative to the ASEAN Intergovernmental Commission on Human Rights, Professor Emeritus 𝗪𝗲𝗋𝗋𝗀𝗃, to give a closing speech for today's seminar. Thank you very much.
Thank you for giving me the opportunity to be here. And thank you for inviting me to give a closing remark on the launch of the book Unpacking the Death Penalty in ASEAN, which provides readers with issues of death penalty in ASEAN region. The book provides readers with different theoretical background which give rise to policy development in some ASEAN countries and reasons why certain policies are maintained. Let me make further comments in the capacity of ASEAN representative who has been involved with the project before this publication. In 2010, 3 thematic studies were proposed by ASEAN Thailand to ASEAN. There were thematic studies on legal aid, juvenile justice, and right to life. Among the 3 thematic studies, the legal aid study is the first to be concluded. The study aims to present a systematic survey of the legal aid system of the 10 AMS ASEAN member states and conduct a regional analysis of the common characteristics of the 10 systems, as well as to propose recommendations to enhance the effectiveness of legal aid at the national and regional level. A regional consultation of the draft study was conducted in 2017, coinciding with the 50th anniversary of ASEAN, and its final key findings were presented at the ASEAN Access to Justice Forum held in December 2018 in Bangkok. The juvenile justice study. The concept note of the juvenile justice study was adopted and included in ASEAN Priority Program in 2015. In 2018, the collaborative research was developed to support the promotion and protection of ASEAN children's rights in the case of children in conflict with the law, CILC, one of the situations identified in the Convention on the Rights of the Child. After submission of national reports by researchers, a regional report was compiled by a regional research team, and the final draft then was further reviewed and approved by ASEAN representatives in 2023, earlier this year. Regarding the last project, Right to Life, the issues surrounding right to life are very sensitive, and it took the ASEAN some years to finally adopt the concept note in late 2017. The study focuses on the protection of the rights of persons convicted of the death penalty. National researchers were identified by respective representatives, while the regional research team was commissioned to a group of academics composed of 6 members from the Philippines, Singapore, and Thailand. The submission of the last country report was transmitted to the regional research team in 2019, and additional research was conducted to enhance the academic aspect of the report. Even though the final draft of the regional thematic study on right to life has not been endorsed by the ASEAN representatives, as the present Thailand representative to ASEAN, I would like to express my sincere appreciation to members of the research team, both national and regional, for their contribution and stamina in bringing the project to its final destination. The issue of right to life covers diverse aspects, legal, moral, or ethical, as well as human rights. The issue also has political and national security implications. It is therefore understandable that the endorsement of the report by 𝐼𝐶 has been difficult. The fact that only 2 out of 10 ASEAN member states have declared abolition of death penalty, and 3 are de facto abolitionists, also results in the non-endorsement of 𝐼𝐶 as an ASEAN sectoral body. Given the complexity of the situation and the diverse theoretical interpretation of government policy makers based on the historical and political background of the countries, non-endorsement of the report by 𝐼𝐶 representative is inevitable. Now the research team has the freedom to present their findings according to the facts and theoretical analysis of the situation in the region. I congratulate members of the research team for their indulgence and insistence in maintaining academic integrity of the report. Thank you.
Thank you very much, Professor 𝗪𝗲𝗰𝗨𝗪 for kindly giving the closing remarks. I think we have it's been a long day for us, so a very interactive and useful, interesting discussion today. On behalf of the faculty of law, 𝐶AN-GONZAGA University, I thank you everyone both from here and from online for staying with us, for participating, and we wish you a safe trip home and good evening. Yeah, thank you.